I got. You're good.
Good morning, everybody. We want to welcome you all for joining us today. We're going to do something a little bit different today. Before we start the presentation, we would like, if you could, please unmute yourself if you're available to, and just kind of give us a background on, give us your name and then what kind of business you own or industry that you are related to. And I guess we can start with the top. Let's see. Conchita, do you want to speak?
Okay, can you hear me?
Yes, ma'am.
Oh, okay. Yes, I'm in economic development. So I'm working with small businesses and property owners and developers who have commercial leases, or they operate, or they're tenants, right? They're on both sides of the equation. So I'm interested from that standpoint. Some of them may be in retail centers, but others are, small commercial properties around town. It might be office duplex or something like that. Again, both on the tenant as well as property owner or developer side.
Great, thank you.
Malachi, do you want to go ahead?
Sure, my name's Malachi. I own a company. We're out back, and I construct, I'm a construction guy, so make, buildings, commercial, residential, stuff like that, home improvements, whatnot.
Thank you.
You're welcome. Thank you.
Mike, do you want to go ahead?
Sure, Mike. Can you hear me?
Yes.
Okay. Yeah, I've been doing management consulting for about 30 years, and it's a wide range, very more of a generalist, including areas in commercial development, housing, renovations. So this is something I've been interested in, and I've been gaining quite a bit of new information from these presentations, especially regarding the COVID-19 impacts in the local areas. I think it's extremely useful.
Happy to hear that. Thank you, Mike.
I have one more from Wick in the chat. He's stating he's unable to speak. However, I am a realtor, property manager of residential and commercial properties.
Okay.
With that, Roberto, I'll let you take it away.
Very well. Well, thank you all for sharing that information with us. It'll be helpful. Just wanted to make sure we kind of knew our audience. And as we move along during the presentation, it's not a whole lot of us. So feel free to unmute yourself. And if something sparks a question or any thoughts, feel free to interrupt and we can talk about it, because at the end of the day, this is more for your benefit than anyone else. So if we welcome you to take advantage of the time and the space and ask away. For those of you that weren't here yesterday or the week before, I can't recall if everybody was here, but I'll give just a brief introduction of myself. My name is Roberto Chavez. I'm a real estate attorney in El Paso. I've been an attorney for a little bit over 6 years. I focus on real estate, both commercial and some residential, but it's mainly commercial, and it's everything and anything from purchase and sale of real property, land, leases, both the landlord and the tenant, entity formation for the purchase of real estate, transfer of ownerships, those kinds of things. And so today's is going to be a little bit more focused on the impact that COVID-19 has had on commercial leases and things just to look out for. But before I get into the meat and potatoes of the presentation, I'll let my partner Adrian give a brief introduction.
Good morning again. Thank you, Roberto. Again, my name is Adrian Slater, commercial real estate broker. and also a small business owner. I think you'll find today's presentation from Roberto very informative. If you were able to attend yesterday, supplementary and also delving a little bit more into the legal terms of a lease agreement. So as Roberto said, we're here to help. If you need any assistance on the business side, I'm here. And of course, Roberto is focusing on the legal side. So Roberto, thank you. Take it away, my man.
Thank you, Adrian. Okay, so last week my presentation focused on force majeure, and that's become kind of a popular clause nowadays because of the impact COVID has had on commercial real estate. But I mean, looking just at a force majeure clause would be like just looking at one aspect of how the current situation has impacted commercial leases. And so the purpose of this presentation is to do a little bit more of a holistic approach into the entire lease. And the idea is to give you some sort of guidance and maybe pointers as you move forward, as you advise people, maybe Conchita, or as you look at actual leases yourself, just to things to be on the lookout, especially as we move forward. Here in El Paso, we're being hit real hard with the second wave of COVID-19. The number of cases has just spiked. And so I know there's a lot of concern from business owners, whether they're going to be able to stay open, if there's another closures coming on, or they're going to reduce the capacity that people are allowed to have in their restaurants or in their place of business. So it's still very, very fresh, and it's very applicable to things that we're going to be looking at here shortly. Okay. So without further ado, let's get started. There we go. So how has COVID-19 affected commercial real estate? So as most of you know, and we've already experienced, there's been shelter-in-place orders by the government, local authorities, state authorities, that completely have cut off access to lease space. As you know, non-essential businesses were closed down for a long period of time, and essential businesses were restricted to a certain percentage of capacity. There's been a major revenue decline for retail and especially customer-facing businesses. Aside from supermarkets that were flooded during a few months there, most customer-facing businesses have really felt the impact of COVID-19. There's been a reduced cash flow for tenants, which kind of brings about the whole discussion, because there's been a mass inability of tenants to make rent payments, and so they're trying to look at any out that they might have, or way to negotiate something with their landlord so that they're not in default, or they're not taken to court, or they can stay open. I mean, the scenarios have been all across the board. Now that we're trying to transition into opening, now there's, what are the safeguards for reopening? What are the guidelines? What do we have to do? What do we have to look out for? And along those lines is, what's the potential liability that business owners now have because they might be exposing customers to COVID. And so these are all different ways that COVID has affected business owners, and each one has its own set of nuances. But what we're going to talk about in specific with regards to those things how COVID has impacted are these things. And so we're going to go into some detail on what events of default, what triggers an event of default under your lease, um, and how does eviction come into play with that. We're going to talk a little bit about tort liability for exposure to the virus. So this is the scenario where, God forbid, somebody goes into your place or to somebody's restaurant and they get exposed and for COVID-19, and what kind of liability does the business owner now have, or to that extent, maybe even the landlord, what kind of liability do they have because of that. We're going to talk about some rent abatement triggers. And so it's basically going through your lease and seeing what causes you to not have to pay rent, and how can you negotiate that moving forward to make sure that you have the language in your lease to protect you in another scenario where there's a shutdown or something similar, that you don't have to pay rent. We're going to talk about your deadlines and cure periods. These are usually the deadlines imposed by your, excuse me. These are deadlines imposed by your lease, whether it's payment of rent or curing any other default, like any other responsibility you might have, like fixing the HVAC or whatever other responsibility you have in the lease, and the cure period, the amount of time you have to cure those defaults. We're going to talk about the types of government relief and how that's helped, especially tenants and some landlords. Continued operation covenants. These are specific clauses in your lease that require you as a tenant to continue to operate, and how to approach them moving forward, and how to maybe modify them with the knowledge that we're not over the hump with this COVID, and we don't know if there's another virus in the future, and hopefully there's not, but just maybe a way to protect yourself in case there is one. And finally, we'll touch a little bit on business interruption insurance, which it's been around for many years, but again, it's one of those things that has come to the forefront of conversation because of the current situation. So we'll approach it from the coronavirus aspect on how business interruption insurance can help you. Okay, so the first one is events of default and eviction. So because of the significant adverse impact of cash flow caused by the pandemic, many businesses have struggled to make timely rent payments. And as you're aware, non-payment of rent is a default under 99.9% of leases. And so almost, and I hate to use the word almost, but a good number of leases says that you have to pay rent within, it's due the first day of the month, and then it gives you a little bit of leeway and says that you have 5 days to cure that default, meaning you're not technically going to be in default as long as you pay rent within those first 5 days. And then other events of default include any repairs that the tenant might have to do. So just as an example, you might have to, as a tenant, the tenant might have the responsibility to fix the HVAC. And so if the HVAC isn't fixed, then you have 15 days from notice of the landlord to cure the HVAC. Otherwise, you're going to be in default. And so the reason I bring events of default up is because I've seen it where you negotiate your events of default to say that your cure period is extended by 45 to 60 days, whatever the case may be. If there's a pandemic situation, there's a stay-at-home decree, or whatever the case may be that you want to include there, that you don't have to pay rent and your cure period is extended for 45 to 60 days if there's an event of COVID or something that doesn't allow you to open up your business. And so this is just one place where you can try and negotiate the clause to extend your cure period so that even though your rent was due the first of the month, you have 60 days to pay the rent if there's one of those triggers, which in this case could be something like COVID-19. So then we've got some liability exposure that I think it's important we talk about. It's very new, and so there's not a lot of case law out there that talks about the extent of liability that tenants or maybe even landlords might have when it comes to people being infected with COVID-19. There was a report done by a very large law firm, Weitzman, Gibson, Dunn, and Kutcher, that believes that most lawsuits by employees, now we're talking about the employee side, will actually be barred by the state workers' compensation scheme. In other words, any kind of exposure would fall of an employee would fall under the workers' comp. Again, it really hasn't been tested. This is not to say that an employer is not liable for any negligence or gross negligence or willful conduct that they might do that might expose employees to COVID. But assuming that they're following all the guidelines that they should be, it's believed that any claim for loss of wages or whatever the case may be with that specific employee should fall under the workers' comp scheme. But then you've got the other side of the coin, which is your customers and invitees and third parties coming into your business. And the fear there is businesses could face personal injury or unfortunately wrongful death claims from customers or third parties for being exposed to COVID-19. And so the number one, and I've talked to several employment attorneys about this, because again, this is not necessarily real estate, but it touches on it. But I've talked to several employment law attorneys. They said that the number one way to defend against that is to have guidelines in place and training and following whatever the CDC is telling you to do, what your state authorities, what your local authorities are telling you to do, industry best practices, follow those, and just make sure that you have, the signs showing that you're requiring everybody to do what is required to reopen. And as long as you can show that you've been doing those things, you should be okay. There really shouldn't be any concern. And on top of that, as we've become familiar with COVID-19, for a customer or third party to say that it was your direct fault that they were exposed to COVID-19 poses a lot of challenges for them to be able to prove the causation of them going to your restaurant or your place of business and then being exposed to COVID-19. sometimes, as we've seen, it takes a couple of days for the symptoms to show, and it's really hard to tell where you got it unless you got it from somebody directly. And so just by the nature of the virus, we believe it's very difficult for anybody to be able to show causation and therefore point the finger directly to you or anybody directly and say that they were the cause of their infection. So in general, just follow the rules and the guidelines for reopening and having customers back in your business, and I think you're going to be well off. Yesterday I just thought of this. I went to pick up some food, and for the first time, it's a small chain here in El Paso. It's a chicken place, and when you walk in the door, they have like this plastic, like a little cubicle area where they spray you with, I don't know what. I'm hoping it's some kind of disinfectant or something. But that's I mean, if I think they're going overboard, but I mean, I felt okay about that, and I felt a little bit safer to know that they're doing that to everybody going in there. But just wanted to bring that up because it was something that I just went through yesterday. Any questions from any of you guys here so far? I'll just pause there for a little bit before I go on to the next slide to see if anybody has any questions or comments. Okay. Oh, I saw here. What about from the property owner exposure liability? Can the landlord run for tenant exposure or tenant customer exposure? So if you're the landlord and you're thinking about renting a space to somebody during these times, I mean, I'll go back. The first thing is you have to look at the what the lease says. Most leases that are pro landlord, Conchita, have an indemnity clause, and that indemnity clause says that if the tenant does anything that causes harm to any other third party that they then want to go after the landlord, the tenant indemnifies the landlord if it was something caused by the tenant. Moving forward, my recommendation, if you're the landlord, is make sure that your indemnity language in your lease is strong enough and specific to say that if the tenant does anything that goes against the guidelines issued by the government or is not doing whatever it is that they should be doing, then they agree to indemnify the landlord for any third party claim. Because at that point, usually what you see is if a customer gets sick and it's a small business owner, well, maybe the small business owner doesn't have the deep pockets. And so a savvy attorney is going to say, you know what, let's just sue everybody and their grandma. And so they'll go after the business owner and they'll go after the owner of the building. Again, here to prove any kind of causation on the landlord would be very difficult. I would say that the best way to protect the landlord would be to shift the responsibility to the tenant. And if the tenant doesn't comply with those things, then the tenant would indemnify the landlord. And it was sent privately, but I'll share with the group. You asked if the landlord should modify the indemnity clause to address COVID-19. I would, but then you get to why will the landlord? So most leases say that you can only change the lease if both the tenant and the landlord agree, and so. And you meant to send, so Conchita meant to send the question to the group, and the question specifically says, should a landlord modify the indemnity clause to specifically address COVID-19? Is there any recommended language? And so, as I was saying, you don't want to, you can't unilaterally change the lease and the language in the lease unless both parties agree, unless the lease says otherwise, but that's very rare. I mean, you usually don't give one party the right to just change the terms of the lease. And so if you're going to change the indemnity clause in the lease, then you're probably going to have to give something to the tenant in exchange. And so it just becomes maybe a negotiation at that point. The landlord says to the tenant, hey, look, I think it's your responsibility to make sure that everybody's safe that comes into your store. And so we're gonna change the indemnity clause to make sure it covers any COVID-19 issues. And in exchange, I'll give you X or Y. And so that's probably the way to get to it. I don't have language off the top of my head that I could think of. But we can certainly talk about that. This was a little bit more focused towards the tenant, so I really didn't look into that, but I'm more than happy to talk to you about that, and maybe we can come up with some more thorough indemnity language that can protect the landlord for sure. Okay, if anybody else has questions, that's great. I mean, I love this. I prefer to answer direct questions that you guys might have. So as we go, as we move forward, feel free to ask any other questions. Okay, so then we get to rent abatement and what triggers rent abatement. As you all may be aware, rent abatement is not having to pay rent for a certain period of time. Your usual rent abatement clauses that landlords will agree to or that are in your leases are if the landlord fails to make required improvements to the property that were agreed to, landlord's failure to maintain the property in adequate condition, or tenant's lost use of some or all of the premises as a result of certain enumerated events or circumstances in the lease. Those are usually very, very strange things to happen. One of them is eminent domain, which is instances where the government comes and takes part of the property, and as a result, the tenant can't enjoy the use of the property anymore, and so they don't have to pay rent. If they can still use the property, but now they only use half, maybe the abatement is half of the rent. And it becomes very specific to your lease. But the recommendation here is that tenants should consider including specific provisions so in future lease agreements to allow rent abatement in the event that the tenant's loss, use, or access to the premises because of government stay-at-home or shelter-in-place order. And so, I mean, this one is very straightforward. The idea here is that if you can't make use of your property because you can't go to your property, you can't have customers coming to your property, then your rent should be abated. I'll tell you, this becomes on an issue of who needs who more, meaning, does the landlord want you more than you want the space, or do you want the space more than the landlord wants you? Because if it's a big landlord and you're just another tenant, chances of them agreeing to something like this are slim. But I mean, if this is a small landlord or a landlord that has maybe just a few units, then they may be willing to take this risk just because they prefer somebody go in there than have the empty space. And so it really depends. But I mean, if you're in a situation where you do have a lot of negotiation room as a tenant, then I mean, this is your golden ticket in terms of hopefully nothing like this happening again, but in the event that there's another kind of shutdown. So to Conchita's point, I thought of specific language or recommended language on the rent abatement. So what I did here is I took a standard rent abatement clause related to hazardous materials, and I kind of adapted it to COVID. So originally it read, in the event that tenant is prevented from using and does not use the premises or any portion thereof for 5 consecutive business days or 10 days in any 12-month period as a result of hazardous substances, which could, in tenant business judgment, taking into account the standards, be a hazardous situation. I went ahead and I included in there as a result of infectious diseases, communicable diseases, government stay-at-home orders, shelter-in-place order, or other related laws limiting the tenant's access to the premises. Just that language right there would in essence kind of give you that out that, okay, now it's not just hazardous substances, which COVID is not a hazardous, well, maybe, but that's not the nature of the clause. Here, by saying specifically what things will cause you to not be able to access your premises because it's a dangerous situation, then your rent would be abated for that period of time. And like Francisca you may have heard her at the beginning, I'm going to share this with her, and she's going to share it with you guys, and so you can look at it in more detail. But the reality is every lease is a little bit different, and I'm happy to assist anybody who has some related issues that you want some specific drafting. More than happy to help. That's the rent abatement. Okay, so deadlines and cure periods. So a commercial lease typically includes deadlines and time limitations for events other than the payment of rent, such as commencement of the lease term. So there's a specific deadline of when the lease term commences when you sign the lease, delivery of possession of the premises to the tenant, termination of the lease, date of completion of any tenant improvements, limitation on time on which tenant may abandon the premises, limitation on time for holding over past the expiration of the lease. And so the reason I list these, and I mean, it's not an exhaustive list, there's other things to consider, is you wanna be aware of your deadlines, so that thinking about another situation as the one we're living through, you may want to modify them or extend them if another situation where there's a shutdown or closure or lack of access to the premises it happens, and you need that extension of time. And so this is, of course, more on the one hand, if you already have a signed lease, then I mean, just become familiar with your deadlines. But if you're looking to renew your lease or sign a new lease, then you want to make sure you try and negotiate that. As an example, you want to lengthen the amount of time with which a tenant may abandon the premises if required by a government stay-at-home order, or allow for extended holding over at the termination of the lease if the tenant is unable to vacate the premises because of COVID restrictions. And so a lot of times this is a very typical provision in leases. It's a holdover provision that says that if a tenant holds over and stays in the premises for a period beyond the termination of the lease, then the tenant has to pay, and I've seen it anywhere from 200 to 250% of their current rate. And so if you're caught in the middle of a pandemic where you can't take your things out, then technically under the terms of your lease, you're going to be responsible for that amount of rent. And so you want to make sure that in the event of something like this, of a COVID-19, you're not going to be charged that holdover rate. And the only way to make sure that you're not is to have it in writing. That's not to say that the landlord will understand and cooperate with you, but legally they don't necessarily need to. So I just wanted to touch on a little bit on the government relief. Federal, state, and local governments have went considerable lengths in attempting to mitigate the effects of COVID-19. As an example, here in El Paso, and I know in other counties in Texas, I know in Travis County, and there's maybe a couple others that I can't think of, they enacted eviction moratoriums. And so I'm familiar with the one in El Paso, so I'll give you a little bit of details on that. So for a period of time on both the residential and the commercial side, landlords were prohibited from evicting tenants. And so people were getting confused, tenants were getting confused, thinking, well, you can't evict me. And for some reason, they were thinking that along with that came the fact that they didn't need to pay rent. And that was not the case. All it was is they weren't, the county didn't want, because people didn't have money coming in and they couldn't pay rent, they didn't want landlords to evict them, because and it made sense there for a period of time, but that doesn't mean that the rent is still not due anymore. Just because there was an eviction moratorium doesn't mean that the rent for those 3 months that there was a moratorium is just forgiven. When that moratorium was lifted, as it was here in El Paso, all of that rent becomes due. And so it was just kind of a temporary solution to a problem that was just prolonged, but just keep that in mind. I don't know if there's any more eviction moratoriums coming up in the future, but just be careful about that. And as I said, I mean, small businesses may not be able to depend on government relief to make rent payments or otherwise support their businesses. Tenants should take extra precautions in negotiating their leases to ensure the survival of the businesses as a going concern without the need for government relief. Again, this is, you can't compare how much more beneficial it is for you to have an out or rent abatement or extended cure periods or any of those things in your lease. Those things outweigh anything that the government might come and pause for a second, like an eviction moratorium. You much rather have something fixed in your lease that will protect you for the entirety of the lease than maybe something like an eviction moratorium. Again, most leases have a clause in them that the landlord includes that says that you have to continue operations. And so these clauses may compel tenants to operate efficiently and profitably by requiring them to conduct regular business at all times during the lease term. It's very typical that the landlord doesn't want a tenant to just suddenly go out of business, or even, let alone COVID-19, just during regular time. They don't want somebody to cease operations and it looks terrible for the space because they're not conducting business. And even though they may be paying rent, you've got their lights off and it just looks terrible for the space. And so they have this clause saying, well, while this lease is in operation, you have to continue to do business during regular business hours and so on and so forth. And so the reason I bring this up is because you may be negotiating cure periods and force majeure and other things in your lease, but maybe you have this stray clause in there that says that you have to operate at regular business hours at all times. Well, you want to make sure that you address this as well, because the last thing you want is to have contradictory clauses in your lease, where one part says you're in default because you're not operating your business the way you should be, but then on the other hand, you have another clause that says you're excused from operating your business. And so you want to reconcile any discrepancies or any contradictory covenants in your lease to make sure that everything is uniform. Then you've got business interruption insurance. So these policies typically require insurers, the insurance company, to pay rent obligations of a tenant or fund lost rental income for a landlord where certain events have caused an interruption to the policyholder's business. And so this one is now very important because I doubt a lot of people had COVID-19 or maybe even a pandemic or anything like that in their business interruption insurance. And so the best thing you need to do is, one, if you already have business interruption insurance, is to call the person who sold it to you and ask them to explain the coverage benefits and list the events that are covered. It's usually, as most insurance policies, they'll want to cover as least as possible. And so if it's not listed, if a certain event is not listed, then it's typically not covered. On top of that, you want to make sure you know what the exclusions are, you know what the coverage limits are, and any deductibles. And you want to know what triggers the policy, because I mean, it all may be fine and well, but there's certain things that trigger the policy going into effect. And just as an example, for a lot of policies, a trigger is that there's actual property loss, like a fire or stolen or anything like that. And so if the trigger is not there, that the trigger may be you're forced to close down, then there might not be that trigger for your business interruption insurance. And you may be paying for an insurance that, yeah, it might cover loss of income because you're closed down, but what is the trigger that lets you tap into that insurance? And so the advice here is become very familiar with your business interruption insurance. Have the agent who sold it to you explain it to you in detail. You read it yourself, get all your questions answered, so that you know what it is that you have and what it is that you're paying for. I wanted to share this this graph with you just because it was pretty interesting. This was as of August, so I don't know what it's been in the last 2 months, but these are litigation cases that reference COVID as a reason, or it's mentioned in those pleadings. As you can see, in March it was very few, and now maybe towards the beginning of August, you've got over 1,000 cases. And this is Texas, by the way. This is not nationwide. And just so that you know, more than 900 of these are business income related. I mean, it's income loss, so it's probably a landlord suing a tenant for non-payment, and they're having issues because they don't have income coming in. Just as a kind of what the industries that are looking at litigation the most right now, it's, as you would have guessed, it's the food and bars. It's the restaurants and the bars are the ones that have felt the impact the most. You've got some healthcare services, some laundry services, and then it kind of narrows down. But yeah, I just I thought it was very interesting. I don't think any of us are surprised that the food and the restaurant and the bars are the ones that are being hit the most, and they're having to go to court to settle a lot of these disputes. And then these are just general business issues that I wanted to touch on that you might want to consider or advise people on, is on just kind of what the general attitude is of your community when it comes to reopening, and how sensitive they are, and that'll probably dictate how exaggerated maybe your precautions have to be, just based on the community. And obviously, I mean, I know it's controversial wearing masks for some people, but I mean, at the end of the day, if you've got a business to run, you have to respect the decisions of others to protect themselves to exposure from the pandemic. And so maybe go above and beyond in helping them make sure that they feel protected and that they're not being overly exposed. So finally, these are just a couple of the main points that we touched on. The number one thing is to know your lease. I mean, I can't stress that enough, both from the landlord and the tenant perspective. I mean, some landlords have their attorneys drafted up, and it's usually landlord friendly, and so there's not a lot to worry about there. But nowadays, I mean, you just have to be really careful and know exactly your lease, both from the tenant and the landlord perspective. If you're the tenant, I mean, negotiate your deadlines and your cure periods to accommodate some adverse consequences stemming from COVID. I mean, no one is stopping you from asking for these things. Worst case scenario is the landlord says, no, I'm not budging on these things, and it is what it is. But I mean, at least try, and the more leverage you have, the better lease you're going to end up with. Try to give yourself a way out. Ensure that there's a force majeure clause, like we talked about last week, that gives you a way out. Make sure your continuing operation covenants are drafted in a way that if there's any issues that come up, you have a way out. And allow for exceptions. You don't have to, there's rent abatement if there's another pandemic, or maybe just some rent reduction if that's what you negotiate and come to terms with the landlord. Something, I mean, and try to make it a little bit more beneficial for you. And then just some general business advice, considering the long-term success of your business when making the decision to reopen. And from a liability and your typical lawyery advice, I mean, just make sure you follow all the government guidelines to limit and reduce any liability and exposure that you might have to any claim of somebody claiming that they contracted COVID because of being in your restaurant or in your shop or whatever the case may be. And so with that, I mean, we've got maybe 5 minutes left or so. If anybody has any other questions, that's the end of the presentation. More than happy to answer y'all's questions if you have anything else. So Conchita asked, there has been a few cases where public facing employees have been verbally abused or even physically harmed when requiring customers to wear a mask in the business establishment? Does the business owner bear the risk exposure because it took place in the property? So are we talking, Conchita, are we talking about exposure of people being exposed to COVID-19 and that kind of exposure? Or are we talking there more of altercation between people? I'm a little lost. And you can unmute yourself if you want. You don't have to.
Okay, can you hear me?
Yes, I can hear you.
Oh, okay. I was having a little bit of trouble with the audio. No, I'm talking about the latter. So if a person is harmed while on that property, not necessarily exposure from getting COVID.
Okay, I wasn't able to get that first part. Could you repeat it?
I'm
sorry.
talking about if the individual is harmed by, when they're on the property, not exposure to getting COVID.
Okay, so the question is there liability to the tenant or somebody being for the customer being there while there's an altercation going on? Hello? Oh, the employee being harmed. Okay. Okay, so yeah, I mean that's a difficult case scenario that you pose for me. Yeah, if there's a situation where there's a customer and he doesn't want to put on a mask and there's an altercation with the employee and the employee is harmed, I honestly I don't know of if the tenant is trying to impose the guidelines, which is you need to wear a mask if you go into a restaurant, let's say, and the employee is trying to enforce those guidelines and he's harmed. I think, and I'm happy to research it a little bit more in detail. I think if the employee is harmed, that would fall under the workers' comp. I think that would be covered because in that instance, I don't think that the tenant, the business owner, did anything wrong, and it would be very hard for anybody to make a claim against the tenant for doing something wrong when all they were doing is trying to impose the guidelines. That would be my thought. Yeah. Any other questions? Okay, well, thank you all for being a great audience and listening to Adrian and myself over these past 2 weeks. Francisco will send you guys our contact information, and we're more than happy to have one-on-ones if you guys have any questions that you think we might be able to help you with.
Thank you, Roberto. With that, that concludes our 4-part series of the commercial real estate and SBD, commercial real estate and small businesses. Again, if you missed any part, please feel free when I send out that follow-up email to let me know which part you would like a video link to, and I'll be happy to send that. Again, I'll include Adrian and Roberto's information in there. Please feel free to reach out to them if you have any other questions. As far as our upcoming workshops, for November, we're actually going to be focusing on social media. So the first one's going to be on digital marketing using Instagram. And then the second part is going to be, is your website ready? Let me include that real quick. And also I included the link for our survey. So if you could please take a moment, again, I'll be sure to send it in the email as well. Take a moment to complete that. That just gives us information about how we did, if there's anything that you would like to see in the future so that we can plan accordingly. And I appreciate everybody. Again, thank you guys. And I hope everybody stays safe this weekend. Okay. Thank you, everybody.
Thank you. Have a good day.
Thank you.
Bye.
Thanks all.